Welcome back. We will now continue with the witness testimony of Ms. Chapuis. Welcome, Ms. Chapuis. I introduce ourselves. My name is Inke Hanefeld. I'm the presiding arbitrator in this arbitration. I'm here with my co-arbitrators, Professor Tawil and Dr. Cremades. You have been called as witness in this proceedings by claimant, and so I need you to read out the declaration that you should have in front of you under rule number 35, paragraph 2 of the exit arbitration rules. Can you please read it out?
Good afternoon. I'll read it in Spanish. Good afternoon, everyone. Witness declaration. I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Please, do you have your witness statements in front of you? It should be CWS 3 and 14.
Sí, tengo aquí.
Yes, I have my witness statement right here of 19 October 2021 and 13 September 2022.
These are your witness statements and that they correspond to your recollection, or do you have any corrections to make?
I think these are them, yes.
Perfect. Then we can proceed. You will first briefly be questioned by claimant's counsel, and then the respondent will continue.
Buenas tardes.
Good afternoon, Mr. Chapuis. I'm going to put some questions to you. The first is, could you explain when you began to work at Minem for the first time? I began to work there in August of 1990. I was assigned to the Ministry of Energy and Mines by the Tintaya Special Mining Company, a state enterprise. And could you explain for us your role in the drafting of Legislative Decree 708? Based on the experience I'd had at Tintaya, I wrote together with Mr. Cesar Polo all or most of the articles in Decree Law 708, especially those having to do with the tax stability agreements. I had worked for 3 years at the Tintaya Special Mining Company, dedicated exclusively to implementing the stability agreement that we had. And my task was every afternoon to meet with 2 inspectors from the Ministry of Energy and Mines who were in an office within our company, and to review with them all of the investments that we had made to build Tintaya 8 years earlier. In addition, we reviewed the investments that we were continuously making in the mine. We were exploring, we were making changes in the concentrator. All of that I would review with the Ministry of Energy and Mine inspectors who were in constant contact with the SUNAT. Going back to the ministry and the first time you were there, could you describe for us the conversations that you had with Mr. Polo regarding the scope of the stability guarantees? Mr. Polo had come from Centromin, a state-owned mining company that did not have a tax stability agreement. Moreover, it had only 7 underground mines, old ones, with a lot of labor problems. I had come from large-scale copper mining with a contract at that time, an agreement at that time. I told him of all of our experience and also the advantages as well as the fragile aspects of the agreements under DL 708. Did you? Well, here in the arbitration, we talk quite a bit about what became the fourth paragraph of Article 86 of the General Law on Mining, which says that stability applies exclusively to the activities of the mining company on behalf of which the investment is made. Did you have conversations with Mr. Polo about this provision at that time? Well, let me clarify that activities, as Decree 708 says, and as other mining laws say, refers exclusively to the mining activities that are exploration, mining, processing or beneficiation, and marketing as well, and transport and mining work. So I sat down with Mr. Polo, and together we would write. We would sit down at a table. He was here, I was here. We would exchange information and go forward in the drafting process. Then we had decided to include the medium-sized companies, those that could only make an investment of $2 million, the existing companies, and the companies that were state-owned and were entering into privatization processes. So Mr. Polo, and here I'm talking about 1990, we didn't have laptops. He was writing, and he told me, so all of the companies that are going to be privatized are figure here. Centromin as well, but Centromin didn't have any factories. So in Peru, since we've had tax stability agreements, and we have had them since 1890, tax stability agreements would only be given to mining. And he said, no, if we are doing that, it could be that when Centromin is privatized, the factories should also receive a tax stability agreement. And he corrected it and wrote that phrase, or that clause, which said this would be only for mining activities of the mining company. And in this way, he sought to exclude the factories. Now, I must clarify that the legislative decrees are signed by the minister and the president, but afterwards they need to be ratified by the Congress. And what Mr. Sanchez did not want was to have any objection whatsoever by Congress. That's why we included that paragraph at Article 11, I think it was, of Decree Law 708. And do you have any recollection as to whether at that time Mr. Polo mentioned that the scope of stability would be limited to an investment project? No, never. He never mentioned that. Moreover, had he mentioned it, I would have told him, you're crazy, you're totally wrong, that's impossible. Mining activities, as we had written even in 708, everything is governed by concessions. If we were signing an agreement for mining activities, that contract, based on the articles of the General Law on Mining, had to be based on concessions. And that is so because we decided that they had to be adhesion contracts, and that Article 3, there's reference to Annex 1, where we were going to indicate the concessions covered by the stability agreement. And also, as we included in 708, for investments of over $50 million, it was going to be 15 years and not one more day. And when did you leave MINEM for the first time? In February of 1993. And when did you return to MINEM? 2001. I went back after 8 or 10 years together with Mr. Polo, who called me to come back. And what were your functions at that time as Director General of Mining? 10 years had gone by, the law had been published, many tax stability agreements had been signed. Peru, even though the copper prices were not helping us, the international price was 80, 85, 90, but investment had come to Peru, and so we had to continuously review studies, applications, plus I was in charge of the environmental aspect as well as the mining security aspect. Could you explain, during the time that you were the director of the DGM, what was MINEM's understanding as to the scope of the tax stability agreements? The understanding, the criterion, has always been that it's based on concessions. Several stability agreements had been signed, more than 20 of them, and you can review them. They are available at the website of the ministry, and they all have the same text because it's an adhesion contract, and they all refer to certain concessions which are in Annex 1. Could you describe the conversations that you had with Cerro Verde in 2003 regarding reinvestment of profits? In 2003, copper prices were 90 cents per pound. And then the officials of Cerro Verde came to my office, and they said that they had depleted the oxides, and they were thinking about finally building the big concentrator that was needed to process the primary sulfides. And they sent me 2 communications where they asked whether the reinvestment of profit was in force. Now, that tax provision had been derogated in 2000. We were in the year 2003. It was no longer the Fujimori administration, it was the Toledo administration. My answer in the meetings we had was that the Peruvian state is going to respect the contracts that have been signed. They sent 2 letters with some inquiries. We answered them. And I think that's here in the record. And what conversations did you have in 2004 with Cerro Verde regarding application of the stability agreement to the concentrator? In 2004, copper prices began to climb slightly. It was at $1.20, and that gave us some breathing room. The mining company situation was not so difficult, and so they came and they said, we've undertaken our feasibility study in respect to the concentrator, and we want to know if it's going to be covered. So we had a meeting with them where, as always, the meetings were my team with the mining companies. I never met with them alone. So we spoke, and they put it to us, and we told them 2 things. The Peruvian state is going to respect this. It's an investment. There's no restriction in the law based on size of the investment. This has been something our country has longed for since 1979. And finally, it's so good that the concentrator plant is finally going to be built. So we said, well, how is this going to be formalized? And so they told me that, well, they were going to file an application. Perhaps they were going to ask for an additional beneficiation concession. So we told them, since the mining unit of Cerro Verde began, had a beneficiation concession where there was a leaching plant and a concentrator. Why not include the new plant in the area of this beneficiation concession? As you know, Cerro Verde had, like this table, 7,000 hectares in mining concessions, and it had a small concession of 450 hectares here that was on top of the 7,500, and that was the beneficiation concession, where all of its treatment plants were grouped together. And so we told them that it could be included. All of this was under mining concession and the beneficiation concession. They were covered by the agreement up until 2013 and not one more day. Thank you very much. I don't have any further questions.
Thank you. Mr. Alexandrov, will you do the cross? Please go ahead.
Thank you very much, Madam President. Good afternoon, Ms.
Good
Chapuis.
afternoon.
I'll be speaking English.
Okay.
You'll be listening to the Spanish translation, I understand.
Okay.
Okay.
Responding in Spanish, correct?
Sí.
Yes, that's right.
Then I will ask you, when I ask you the question in English, make a pause before you respond so that the interpreters can catch up.
De acuerdo.
Once you respond,
Fine.
I'll do my best to make a pause myself, again for the interpreters to catch up. I ask you that you don't take my pause as an invitation to continue talking. I will just make a pause for the interpreters to catch up.
De acuerdo.
Fine.
So ask you to keep your answers brief to the extent possible. You testified at the hearing in the parallel case, the Cerro Verde case, in February, correct?
Sí.
Yes.
Did you review the transcript of that hearing?
Yes, I reviewed my transcript.
When you say your transcript, do you mean the transcript of your testimony?
I only reviewed my testimony.
Nothing else?
Nothing else.
The opening statements?
I did not review them.
You will recall that you testified at that hearing that you were paid for the time spent to prepare your witness statements and for the time spent to prepare for your testimony at the hearing and your testimony at the hearing. And you testified that you charged a fee of $250 per hour. Do you remember that?
Sí.
So, yes.
Are you paid the same rate to prepare your witness statements and prepare for and testify at the hearing in this case?
Sí.
Yes.
How much total have you charged Cerro Verde and or Freeport so far for preparing your testimony in the Cerro Verde case and preparing your testimony and for the hearing in Freeport versus Peru?
Several hours. I don't recall the exact number of hours, so I could not give you an exact figure. I work for other institutions and other consultancies, and I have a weekly timesheet. And there, I note how many hours, and I give that timesheet to my accountant. At this time, I don't want to answer because I might end up telling you a figure that's not correct. I almost can't hear you. Could you speak a little closer to the microphone or speak up a bit?
Disculpe usted.
Okay, my apologies.
We all know how this works. We record our time and then give the number of hours to an accountant who prepare the invoices. So you have to know how many hours you've spent and for how many hours you've charged Cerro Verde and or Freeport. Your accountant cannot come up with that number. You feed that number to the accountant. So you've got to know when you give those timesheets to your accountant how much time, how many hours you've spent and you've charged for Cerro Verde and or Freeport. Isn't that right?
As I told you, I work for other institutions and I do consultancies with other companies. And each week I prepare a timesheet that indicates the number of hours that I spend on each job, and I give that to my accountant. It's my understanding that in respect of this hearing, that in this hearing I need to give exact, precise answers. So I could tell you at this point in time 20 hours.
And when you say 20 hours, you mean in preparing for this hearing, correct?
I would like to make a note.
Answer my question, please.
No,
You said, it is my understanding that in respect of this hearing, that in this hearing, if I need to give an exact, precise answers, I could tell you at this point in time 20 hours. So I'm just asking you to confirm. Is it your testimony that you have spent and been paid for 20 hours for the time that it took you to prepare for this hearing?
Lo que yo quería decir.
What I wanted to say, Mr. Alexandrov, is that I'm not getting the interpretation.
Translate my last question.
No sé si tengo que apretar otro botón.
Perhaps I need to press another button.
Make sure she's on the right channel, please.
Yes, you will receive assistance. My apologies if you do not hear the translations.
Yeah. Okay.
Do you hear the Spanish translation now?
Sí.
Yes, now I do.
In respect of this hearing, if I need to give an exact, precise answer, I could tell at this point in time 20 hours. So I was just asking you to confirm that you spent 20 hours in preparing for this hearing. Can you confirm that?
Yes, more or less 20 hours.
Mr. Chapuis, do you review the invoices that your accountant sends to your various clients?
Yes.
Do you have any idea about the amount of your invoices to Cerro Verde and or Freeport?
I'm going to be very sincere with you, Mr. Alexandrov. I'm more concerned about the invoices that other clients delay in paying.
Well, I'm glad that Cerro Verde and Freeport are paying you promptly and you're not concerned about that. Nevertheless, since you review your invoices, you must know, and you may not remember now the precise number in terms of cents, but you must have a general idea of what is the total amount of your invoices issued so far to Cerro Verde and Freeport. So what is it?
I wouldn't dare give an exact number. As I said, for these lat ones, 20 hours, $250, $5,000.
Well, but I understand your math exercise. You're multiplying 20 hours by 250. But the 20 hours I understood was just to prepare for this hearing. And I'm asking you for the total amount that you have invoiced so far. And just give me a ballpark.
Perhaps $7,000. Look, sir, Mr. Alexandrov, you have to recognize that in Peru we pay taxes. Consultants pay taxes, and we have rates. And right now I'm having an issue trying to think how much I ended up charging, because in Peru we do pay taxes, high taxes at that. Would you like the gross or the net amount?
Sorry, maybe I just misunderstood the numbers that were stated. Was it right on the transcript? Perhaps $7,000? I understood something differently. What she said? Okay, 7,000 so far.
That's what she said, but I'm going to pursue that a little bit. Well, first of all, Ms. Chapuis, I understand you pay taxes in Peru, so I'm not questioning that. In response to your request for clarification, I'm asking you how much you have been paid so far before taxes. So if you want brutto, if you will. But let me ask you about the number $7,000, because you just said that you spent 20 hours preparing for this hearing, which is $5,000. Are you saying that for preparing your written statements in the other case and in this case, and preparing and testifying at the hearing in the other case, you are only paid an additional $2,000?
No,
No, sir. No, Mr. Alexandrov. My understanding is that you asked me how many hours did you take to prepare this hearing today. I haven't invoiced Cerro Verde yet.
What I'm asking you, let then split it into two questions. My first question is, how many hours, more or less, you have spent preparing your written witness statements in the other case, preparing for and testifying in the other case, preparing your witness statements in this case, and preparing to appear at this hearing. Total, how many hours so far?
Okay, let's split these things up. You have asked how many hours I took to prepare this, and today's.
I will repeat my question. The two witness statements you submitted in the case of Cerro Verde versus Peru. Your preparation for the hearing that we conducted in February, your time at the hearing, and then, in addition, how many hours you spent preparing those two witness statements in this case, and how many hours you spent preparing for this hearing, total.
Well, let us say that I have not submitted the time sheet for this week, where I have reviewed all these documents, my testimonies, and right now I am now testifying at a hearing. Now, if we exclude this, I think that after taxes, the server has paid around $7,000.
I'm just waiting for the transcript to show what you've said. Well, if I'm not mistaken, Ms. Chapuis, I'm not asking you after taxes because I don't know and I don't want to know what taxes you are paying. I'm asking you before taxes. What you were paid by Cerro Verde and or Freeport. No, not what you end up after paying taxes on those amounts. So can you answer that question, please?
I would have to think about a more imprecise calculation. Taxes are not based on flat figures. As figures go up, the tax rate goes up. Let's just say that perhaps $10,000. That could be an amount. I also need to make another clarification, Mr. Alexandrov. You seem to be very interested in this. Cerro Verde covers my trip, hotel, flight, food when I am away from my country, being at a hearing. So the amount is much higher, right?
To be clear, I'm not asking about your costs, your hotel and your travel. I'm asking you about the remuneration you receive for your time, which you said you charge $250 per hour. And so if you received $10,000 so far, that by my calculation is 40 hours at the rate of $250. You said you spent 20 hours preparing for this hearing. It seems to me difficult to understand how you spent 20 hours preparing for this hearing and then you spent just 20 more hours preparing your 4 witness statements and preparing for the other hearing. Can you explain that?
Doctor,
Mr. Alexandrov, let's see. First, this last stage, well, I haven't charged Cerro Verde anything for it. I have my time sheets that I have kept day by day, and I have written on there how much time I spent. I have not collected anything. In connection with the 7,000 or 10,000 before taxes, I have not included this last stage. We have not finished with Cerro Verde. My time sheet will end when I arrive on Friday at my place, and I said, okay, I used up so many hours for Cerro Verde, and I go day by day. That last calculation I have not performed yet.
Okay, so what I understand is this. You were paid $10,000, which is 40 hours of your time, before you started preparing for this hearing. For the time you spent preparing for this hearing, you estimated 20 hours. I'm still having some difficulty understanding how is it that you spent 20 hours preparing for this hearing, but you spent a total of 40 hours preparing for the February hearing and then preparing for witness statements. Can you explain?
What are the 4 witness statements that you're referring to?
The case and 2 in this case.
No,
No, sir. I am saying that whatever has to do with this stage that started in April and that we are concluding today for me as a hearing, well, then I'm going to leave here, go to the airport, arrive at my place, and then, and only then, am I able to calculate how many hours I used. That has not been invoiced yet. The timesheet is not completed yet. I still have to add this hearing and my return to Lima.
Now I understand that. You're saying you haven't invoiced the time you spent preparing for this hearing. I understand that. I also understand you said you spent 20 hours preparing for this hearing. But what you have invoiced already must be your 2 witness statements in the other case, your 2 witness statements in this case, that is 4 witness statements, plus the time you prepared for the hearing in February and the time you spent at the hearing in February. And my question to you is, if just preparing for this hearing took you 20 hours, which you have not yet invoiced, isn't 40 hours spending on all the rest, 4 witness statements and preparing for the other hearing, a fairly low number?
Sir, I know that this is being translated, but I have only prepared this, and I have looked at this. This was my presentation, or my statement at the February meeting where you and I met. And I started preparing for this about 2 weeks ago, and I haven't finished completing my time sheet. And when I get to my house, I'm going to conclude filling out the timesheet. I'm going to send the invoice to Cerro Verde, including my expenses. I have to put together all my expenses, taxis, hotels, meals, etc.
So are you saying that the $10,000 cover the invoiced amounts in this case only, your 2 witness statements, and whatever else you did for the purposes of this case, and you do not include in that number the compensation you received in preparing your 2 other witness statements in the Cerro Verde case, in your preparation for and participation in the hearing in that case? Is that your testimony?
As I said, you asked me how much Cerro Verde had already paid. From what I recall, up until February, and I was at a hearing in February, and you were also involved in that hearing. Well, up until February, the amount is around $10,000. That's just my fees, because then I have charged Cerro Verde all of the expenses related to hotels, flights, taxis, meals.
Ms. Chapuis, I'm having some difficulty trying to understand how much you've been paid. And I don't know if it's my difficulty or you're not being straightforward. Do you believe there is anything wrong that you were paid for your testimony in this case?
I do not, in no way.
Then why don't you just say, this is what I've been paid so far, and I expect I'll be paid for the rest of my time when I invoice it?
I have not yet calculated how many hours. We have not finished this, Mr. Alexandrov. If you are going to ask me questions during 2 more days, I'm going to have to invoice 2 more days to Cerro Verde.
Well, I was asking you what you have invoiced so far. I understand that you are yet to submit invoices. I can see that Cerro Verde is thrilled with anticipation to receive those, but in the meantime, I was asking how much you've invoiced so far, and I understand that there is some time that you have not yet invoiced, but again, how much you have invoiced in both cases so far.
Let me explain this to you, Mr. Alexandrov. When was the hearing? February 5th, right? February 3rd, February 5th? Let's just say February 4th or 5th. Then the hearing ended by midday. I went to the hotel, I packed, and then I went to Lima. I arrived in Lima, and I put together my invoices, all my timesheets, and I sent the invoices to Cerro Verde. All of the expenses that I had made, hotel, meals, flights, I added everything. Now, that, of course, is taxed in a special manner. Then I included my hours. Day so-so, day such and such, hearing, we ended at 11 in the morning, so I wrote 11 in the morning, etc., etc. And I invoiced the amounts to Cerro Verde. I think I would have invoiced everything by February 15. If we look at February 15 backwards, I calculate that with the preparation of this witness statements and the other, about $7,000 after taxes.
Your first witness statement in the Cerro Verde case was submitted on 27 August 2001. Not this one, not the other one, but the witness statements in the Cerro Verde case, 27 August 2021.
Madam President, witness statement is not on the record here, so she can't verify that.
She can take my representation for that, and I'm sure you'll correct me if I get the date wrong. 27 August 2021. So let me ask you then this: you are paying taxes in Peru. How much were you paid by Cerro Verde for your participation in both cases in 2021?
Let's see. Let's clarify something, Mr. Alexandrov. Here we have a witness statement. It appears to be the first, 19 October 2021. That's the date it appears. A year and a half ago. Then there is another witness statement that is a response to what other witnesses were saying.
Not have been clear. I'm not talking now about those two, right? I'm talking about your testimony in the other case in which you testified in February. And there you also submitted 2 witness statements. And the first one was in August of 2021. Not this one. Not this one. In the other case. You submitted the first one in the other case in August of 2021. So you must have done some work in August of 2021. How much you were paid total, brutto, in 2021?
Now I understand, Mr. Alexandrov, just now. My apologies. Here, this is a witness statement for Freeport, and the other one was a witness statement for Sumito. So what I recall is that, practically speaking, they are the same. I do not recall having prepared 4 different witness statements.
No. Nevertheless, could you please answer the question, how much were you paid by Cerro Verde or Freeport? Who's paying your invoices? Is it Cerro Verde?
SMCV, because I issue my invoices in Peru, and that is the mining company, the Peruvian mining company, that I can issue invoices to, because they have a taxpayer number in Peru.
2021.
I do not recall. That is why I said that up until February, around February 15, 2023, for everything that I had done, all of these witness statements that you say that they are for, okay, now I realize that they are for 2 for Freeport and 2 for Sumitomo, but really there are 2. There are 2 that are the same. So the approximate amount is $7,000, rather $10,000, and after taxes, $7,000.
You have testified and you responded to questions by Dr. Prager that you first joined MINEM in 1990, correct?
That's exactly right. August 1990. 30 August 1990. 33 years ago.
In your statement, you say you were a secondee to Vice Minister Polo, correct?
I was an advisor of the Vice Minister of Mines.
The Vice Minister was Mr. Polo.
Exactly, right.
Before that, you had no government experience, correct?
My experience was having worked for 3 years for the state mining company, Tintaya.
So you worked for a state-owned company, but to respond to my question, you did not work for the government, correct?
No.
No, I worked for a state-owned company. It was a private law company.
Now, your first job as a junior engineer was for Compañía Benaventura, correct?
No. I hadn't really obtained my title as an engineer, as a mining engineer. I was a few months away from it. So I was just practicing.
First job?
Sí.
Yes. It was my first job in an underground mine that was very small in the Huancavelica region in Peru.
And Compañía Buenaventura is the same company that in 1994 participated together with Cyprus Minerals in the privatization of Cerro Verde, correct?
That's exactly right.
And you're aware, aren't you, that Compañía Buenaventura acquired 9.2% of the shares in Cerro Verde at the time, correct?
In November 1994.
Sí.
Okay.
Yes.
And you are also aware that the same company, Buenaventura, owns 40% in Yanacocha, correct?
That's exactly right.
And the founding president of Buenaventura is Mr. Alberto Benavides de la Quintana, correct?
That's exactly right.
Bueno, ya falleció.
Well, he passed away already.
I should have said.
Sí, falleció, sí.
Yes, he died a while ago.
You know his youngest son, Mr. Raul Benavides, correct?
Raul Benavides was at the Catholic University with me. He was also a student of mining engineering up until the third year, and then he left the Catholic University and he came to the U.S. to finish his engineering studies.
Right. See, if I remember correctly, he was expelled. And so he came to the United States to complete his education. Am I right?
At the Catholic University, you could not repeat a class a third time. So that is why he was expelled, and he repeated a class 3 times, so he had to leave the Catholic University.
You keep in touch with him on a regular basis, don't you?
No, I do not.
Well, you had a chat group called Huascaminas in which he participates, correct?
The School of Mines of the Catholic University is very, very small. The School of Mines is very, very small. All of the graduates, about 180 people so far, 180 professionals. Well, when What's Up came up, we created a WhatsApp group that's called Huascamina, and we exchanged news and notices.
In addition to interchanging communications, you also had regular meetings at the rate of once a month, correct?
We now hold meetings because 20 years ago, all of us were working in different mines. We were spread around throughout the country.
Ahora estamos.
We're now retired. We have more time.
So you do have meetings once a month, correct?
Well, we could say every 1 or 2 months. Well, those who are able to go to the meetings go, those that are free. But it's not only meetings we hold, we also go to funerals.
Unfortunately, that's life, but I'm not going to focus on that at the moment because we have more pressing things to do. I want to show you your testimony at the hearing in the other case, which I refer to as the Cerro Verde case. And it is tab 5, C1135. That's day 3 of the transcript at page 789, 790 of the English. The Spanish is 779, lines 2 to 16. We will show it on the screen if that's easier, whatever is easier for you. And I was asking you, I'll read from the English. Can you tell us a little bit about this group, which I think you called, it's not in the translation, but you called Huascaminas? And you answered, yes, we're all graduates of the Catholic University from the School of Mines. We call ourselves the Huascaminas, and we meet once a month. We have ceviche together. Do you confirm your testimony?
Perdón, ¿en qué página está?
I apologize. What page is that?
It's 779, lines 2 to 16. It's also on the screen to help you orient Ms. Chapuis.
Aquí está.
I found it.
Well, do you confirm your testimony?
Yes.
Then
Sorry, Mr. Alexandrov, when you say you confirm your testimony, specifically of what you have asked, because we're, at least I'm not aware of all her testimony, no?
right. So, do you confirm your testimony that Mr. Raul Benavides is a member of that group called the Huascaminas, and you meet that group, we meet once a month, and we have ceviche together? Do you confirm that?
Yes, but let me clarify that this is an open meeting and oftentimes I do not have time and I do not attend.
Understood. And then I asked you, and it's day 3 at 790. And the Spanish, it's the same document, page 780, lines 1 to 4. I asked you, are you still in contact with him meaning Mr. Raul Benavides, through this professional group or otherwise? And you answered, yes, I see him at meetings generally. Can you confirm this testimony?
Sí.
Okay.
Yes.
Did you know during your tenure at the ministry, the second one from 2001 to 2003, that he, Mr. Raul Benavides, was a member of the board of directors of Cerro Verde?
No sabía, doctora.
I did not know that. I learned through you because you presented board agreement, and he was the director at that point.
You didn't know that when you were at the MINEM.
Esa información
As to the information as to who are the members of the board is not something that we saw in the information that we reviewed.
Let me show you a document which is behind tab 13 of your binder, which is Exhibit C 470. This is a meeting of the Board of Directors of Cerro Verde, and when I refer to Cerro Verde, I mean Sociedad Minera Cerro Verde. And you see that this is meeting minutes of the Board of Directors of Cerro Verde. And the fifth name down the list of participants is Mr. Raúl Benavides Ganosa. Do you see that?
sí, este fue el
Yes, this was the document that you showed me at the last hearing in February, and that's when I learned that.
For any of the two hearings, you did not see that document.
no.
No, I did not.
And during your regular meetings, it never came up that Mr. Raúl Benavides is a member of the Board of Directors of Cerro Verde. Is that your testimony?
Nunca,
To begin with, based on the document that you presented, he was director in October 2004, and at that point in time I was working at the ministry and I did not have time to attend any meeting.
Was a little bit different. You testified that you learned for the first time that Mr. Raúl Benavides was a member of the board of Cerro Verde when I showed you this document at the February hearing. And so my question is slightly different. Is it your testimony that during all those regular meetings which you attended, it never came up in any conversation that Mr. Raúl Benavides was a member of the board of Cerro Verde?
las reuniones,
The routine meetings of the group Was Caminas started when we created a WhatsApp group with the 180 graduates from mines. So now when we have a good number of people who are retired and we organize meetings at a restaurant and we offer this opportunity to whoever wants to go. I attended some, but not all, because I am short of time too.
That group was organized in 1976, correct?
no, este es un grupo.
No, this is a WhatsApp group. When was WhatsApp created? I don't have it fresh in my mind. I guess 5-6 years ago.
The WhatsApp chat group. I'm talking about the group of graduates who started regular meetings.
As I mentioned before, as we were all working, most of us are at 67 years of age, and we have been working until recently. We just started, a great deal of us started to retire and to have time to be able to meet. Before then, they were all over the country working for mines.
Ms. Chapuis, this is not an answer to my question. just to give you the background of why I'm asking, and then I'll repeat my question. We established, and you testified in the February hearing, and you confirmed this testimony today, that there were regular meetings once a month where you had ceviche. And I'm asking you, you're giving me answers about people don't have time to go to those meetings. I'm asking you, you attended, I'm not saying you attended all those meetings, you did testify there were regular monthly meetings, you attended, I'm not asking how many of them, you probably won't remember, but you attended at least some of those meetings, and my question was a bit more specific than what you answered. My question was, is it your testimony that during those meetings it never came up in your conversations with Mr. Raul Benavides that he was a member of the board of Cerro Verde?
Mr. Alexandrov, Mr. Benavides, according to this document,
Yes or no, then you explain. My question is again, is it your testimony that during those meetings it never came up in your conversations with Mr. Raul Benavides that he was a member of the board of Cerro Verde?
Mr. Benavides was director of Cerro Verde in 2004 when I was the general director of mining and I did not have time. Then there was no WhatsApp, there was no chat group for Huascaminas. At that point in time, I did not have the time to attend meetings. I stated in February that now, over the last recent months, there are some monthly meetings, and sometimes I'm talking about 2023 when many of my colleagues have already retired. We are 66, up to 68 years of age, and we have started with these meetings. I am not talking about 2004.
Usted podrá.
As you may imagine, this meeting is held in Lima. As you may imagine, 20 years ago we were 45 years of age and we were leading a mine somewhere in Peru, far from Lima.
Ms. Chapuis, I'm making a pause simply to let the interpreters catch up. Please don't take that as an invitation to continue your answer. Thank you for your answer. So let's go to the same. Actually, can we go to the same document, C470? I apologize for my voice. Again, this is a meeting of the board of Cerro Verde, dated 11 October 2004, and look at section 1, and you see that at that meeting, the board approved the investment of $850 million for the primary sulfides project, which is the concentrator plant. Do you see that, Ms. Chapuis?
Sí.
Yes?
So, and we know from that same document that Mr. Benavides was one of the 5 directors who participated in that decision. Did you know that the board of directors of Cerro Verde approved the investment into the concentrator plant in October of 2004?
Yo no sabía,
I was not aware of that. Learned that at the February hearing in 2023.
Can we look at the testimony of Ms. Torreblanca, second witness statement, CWS 21, at paragraphs 16 and 17. And that's behind tab 15. Do you have the screen? I'll wait for a minute.
Gracias.
Okay, so can we look at Ms. Torreblanca's second witness statement, paragraphs 16 and 17? You have them behind tab 15. I'll refer to them in English. You can look at the Spanish. So here is what she says in paragraph 16. She says, Director Chapuis and other minimum officials were sufficiently persuaded that Cerro Verde's case was distinguishable from that of Tintaya. Director Chapuis explained that since the new concentrator investment would form part of Cerro Verde's existing integrated mining unit, it would be covered by the existing stability agreement. She told us that there was no need for an amendment to the stability agreement to include an additional beneficiation concession. Rather, since the investment in the concentrator would be made within Cerro Verde's existing mining unit, Cerro Verde could simply apply for the extension of the existing beneficiation concession that was already covered by the stability agreement. Then she continues in paragraph 17, in light of the DGM's confirmation that the concentrator would be covered by the stability agreement if it was included in the existing beneficiation concession, Cerro Verde no longer saw the need to press for additional written guarantees. On 11 October 2004, Cerro Verde's board of directors met by telephone conference to determine whether it would approve the $850 million investment to build a concentrator. Then she talks about her participation and says the board of directors decided to approve the investment, conditionally noting that the meeting minutes that the final approval would depend on obtaining the required permits and the financing necessary for the project. Do you see that?
Sí.
Yes.
It was on the basis of your oral assurances that the board conditionally approved the $850 million investment in the concentrator plant. Did you know that at the time?
I did not have any idea as to the steps to be followed within the board of Cerro Verde.
Subsequently, shortly after that, Compañía Buenaventura increased its participation in Cerro Verde to about 20%.
No sabía.
I did not know.
Can we look at paragraph 6 of your first witness statement? You say, the second sentence, between July 1993 and November 1997, I engaged in consulting work for mining companies, including the Phelps Dodge Corporation. None of my private consulting has involved Cerro Verde. Do you see that?
Yes.
Let me show you document RE 200, which is behind tab 9. And this is your curriculum vitae in the Spanish on page 4, English page 3. You explain what you've been doing under the rubric in English, Technical Economic Evaluations for Investment Decisions, Permit Management, in Spanish, evaluaciones técnico-económicas para decisiones,
Technical economic evaluation for investment decisions,
including Phelps Dodge, USA, 1993-1997. Do you see that?
Sí.
yes.
According to your CV, you worked on technical economic assessments for the purposes of investment decisions for Phelps Dodge between 93 and 97. So for 4 years you were consulting Phelps Dodge on investment decisions. That's what your curriculum vitae says, correct?
Yes, on those years, yes.
Can we look at tab 18? And that is C318. It is a document of Phelps Dodge, and the heading is 1993 Cerro Verde evaluation. Do you see that?
Sí.
And then when
Yes,
the page after the title page and the table of contents, you see section 1, executive summary. And I'll read the paragraph in English. Phelps Dodge Mining Company, consistent with strategic plan objectives, is interested in acquiring and developing quality mining properties in mining regions throughout the world. Phelps Dodge initially became interested in the Cerro Verde open pit mineral property in Peru because of its large copper ore reserves, the privatization of the state-owned mining concern known as Minero Peru, and the improving investment climate in Peru. A Phelps Dodge evaluation team visited the Cerro Verde data room in Lima and the mine site in southern Peru near the city of Arequipa in May 1993. And then I want to show you another document, tab 19, C367, which is Phelps Dodge SEC Form 10K of the year 2000, and it's page 38, which is the last page of the excerpt. On the PDF is page 44 in the full exhibit. It's the paragraph, the rubric, well, the heading is PD Mining Operations Update. And you see Phelps Dodge is reporting to the Securities and Exchange Commission that, quote, on October 16, 1999, Phelps Dodge acquired Cyprus Amax Minerals Company. And then under rubric little Roman 5, an 82% interest in the Cerro Verde mine in Peru, consisting of 2 open pits, a heap leach operation, and an SX-EW plant. Do you see that?
Sí.
Okay.
yes,
So what's happening is Cerro Verde expresses a strong interest, Phelps Dodge expresses a strong interest in Cerro Verde in 1993 to the point of entering the data room in Lima and visiting the site, and then which culminates in 1999 with the acquisition of 82% interest in Cerro Verde. You were a consultant of Phelps Dodge on investment decisions, and your testimony is this one big investment by Phelps Dodge in Peru that was very seriously considered during those years never came up in your work for Phelps Dodge. Is that correct?
Sí.
Yes.
En 1993,
In 1993, as I mentioned before, I left the ministry in 1993, February 1993, and approximately in June, July 1993, I was called by Phelps Dodge from the office in Chile. I was asked to conduct some assessments, in particular for Tintaya, since I had worked there, and then another mine in Chapi, which was a private mine. Francisco Kaiser, the engineer, told me at that meeting that we have discarded the project, Cerro Verde project, completely. It is a disaster. The Peruvian government would have to pay us $30 million if they want Cerro Verde to go into that mine, if they want Phelps Dodge to go into that mine. In November that year, privatization happened, and only Cyprus presented an offer for $30 million. Phelps Dodge did not present any offer, and none of the other 18 mining companies that had acquired documents for the privatization offered any bid. The only one that presented a bid was Cyprus, and they got the privatization. 6 years later, Phelps Dodge bought Cyprus, and those are the typical mergers among mining companies, and Cyprus arrived with all of their assets. One of them was Cerro Verde.
This was the only one who submitted a bid. And that Phelps Dodge at that time did not. My point is slightly different. Cerro Verde expressed a strong interest, including accessing the data room and sending a team on site. So clearly, there was an investment decision to be made. Whether in 1993, 1994 they made a decision not to participate, it was still an investment decision. Eventually, they made an investment decision to obtain over 80% of Cerro Verde. And my question is, you are their consultant on investment decisions. You are based in Peru. You knew the Peruvian mining sector, as you have testified, upside down. And you never advised Phelps Dodge on this investment decision whether or not to acquire Cerro Verde. Is that your testimony?
As I told you, engineer Francisco Caixa said that it was a disaster in June 1993 and told me it's a deposit, but there's no water and there's no electricity.
And who was that person again?
Francisco Caixa, who was from the engineering area in Phelps Dodge and worked in the Santiago office. He came from Bechtel, which is a larger engineering firm, and he was the one who interviewed me. And in a conversation talking about Tintaya and Chapi, it came up, and he told me that Cerro Verde is totally discarded. The Peruvian government would have to pay us $30 million to Phelps Dodge for us to take on that mine, which is a disaster.
Learned that from Phelps Dodge person in Santiago de Chile. Nobody from Phelps Dodge ever approached you in Peru to consult you on that decision. Is that your testimony?
Exactly. That was the only time when I heard about Cerro Verde.
You were their advisor on investment decisions, and you're saying You only advised them on an investment decision in Chile, and that was all, correct?
No.
No, not any in Chile. I said in Tintaya and in Chapi, which is in Arequipa. Plus, I was one of the consultants. These are very large companies. These are investment decisions that entail more than $100 million. And as you could imagine, I was not the only consultant who decided whether such an investment might be made by Phelps Dodge. It was the exploration office in Santiago, and they're based in Phoenix, I believe. That's where headquarters is, and that's where all the decisions are made.
Well, I understand, of course, that you are not the only consultant of Phelps Dodge. I just find it somewhat strange that they would consult you with respect to Tintaya and Chape, but not with respect to Cerro Verde. You didn't find that strange that they never talked to you about Cerro Verde other than your conversation with the person in Chile?
As I say, that was July 1993, and it was already discarded. And that is confirmed because in November of 1993, they did not present any bid.
In 95, 96, 97, when you were still their consultant on the investment decisions, they never talked to you about Cerro Verde?
As I say, engineer Francisco Kaishek told me that that project was a disaster. It had no water and no electricity.
3. I'm asking you, how about the years 95, 96, 97, when you continued working as a consultant on investment decisions for Phelps Dodge? Did anybody from Phelps Dodge talk to you about Cerro Verde during those years?
No one. That project had been completely discarded.
Madam President, this may be a good time for a break.
Yes, then we have a 15-minute break. Thank you.
Mucho, mucho. Te amo, te amo, te amo, te amo, te amo, te amo y me haces mucha falta. Te amo, bebé. Te amo, te amo, te amo. You changed channel. I'm sorry, were you unable to?
think we can proceed.
Thank you, Madam President. Ms. Chapuis, I want to talk a little bit about your position from 1990 to 1993 as an advisor to Vice Minister Polo. And in particular, your role in drafting Decree 708, which was the mining law. So can we look at your witness statement, your second witness statement at paragraph 5, which is in your, you have it in front of you, but for everybody else, it's behind tab 2 of the big binder. You can read it for yourself first, Ms. Chapuis, so that I don't read it into the record. Everybody has it. Your second witness statement, it's probably easier to look at one of those, yes? September 2022. Can you take a look at paragraph 5, and then I'll ask you about paragraph 6. So, paragraph 6, you say, first of all, I was surprised to learn that Peru claims Mr. Polo's testimony in this arbitration is determinative because he supposedly, quote, spearheaded the drafting of the provisions of Legislative Decree 708, close quote. This is not correct, you say. As I explained in my first witness statement, President Fujimori's First Minister of Energy and Mines, Fernando Sanchez Albavera, was in charge of drafting Decree 708. Around August 1990, after a few days in the office, Minister Sanchez Albavera asked Mr. Alejandro Portal, financial manager of Empresa Minera Especial Tintaya, to provide a secondee with relevant experience in mining and finance to advise Vice Minister Polo on various issues, including the drafting of provisions related to stability agreement in the mining reform. And Mr. Portal asked me to take that role, and I accepted. Do you see that?
But
Excuse me, what is your question?
I just want to make sure you've seen that, and then I'll proceed.
Yes.
Well, so let us look at the transcript of the February hearing, which is behind tab 5, Exhibit C 1135, which is the transcript of day 3 at page 780 in the English and 864 in the Spanish. And in English it begins on line 6 with my question. Oh, sorry, this, I apologize, it was Mr. Prager who asked that question, I'm sorry. I'm honored to be confused with you, but I'm not sure you're honored to be confused with me. Apologies. Mr. Prager is asking the question, and the question is, and I'll read it into the record. Could you describe for us the conversations that you had with Cerro Verde as to whether the stability agreement would apply to the concentrator? And you say, yes, I spoke with the technical legal team. There was no objection anywhere. Plus, I had written the law. I understood perfectly well what the spirit of it was. Okay, so then we'll look at another portion of the transcript. And it's in the English 782. Again, day 3, page 782. And it begins with the question, again by Mr. Prager. You said that it was clear. Can you explain what was clear? I'm waiting for this to appear on the screen, and then I'll read it into the record. So, line 17. You said it was clear. Can you explain what was clear? And your answer is, well, as I have explained, I wrote this law. So I knew quite clearly that what the company had to show was that it had complied with a $50 million investment as a minimum. Then let us look at page, I believe it's 806. And in page 806, this is now me asking the question. And I say, beginning at line 5, now you said you testified in your witness statement that you drafted the mining law, and in particular Decree 708, that became the mining law. And in fact, you said twice during your direct examination, quote unquote, I wrote this law. And I asked you, do you confirm that testimony? And you said yes. Now, during your direct examination this afternoon, in response to questions by Mr. Prager, you explained that you and Mr. Polo, sitting together at the table next to each other, drafted the law together. So my first question is, which one is it? In February, you said 3 times, I wrote the law. Now you're saying Mr. Polo and I sat down at the table and together wrote the law. Which one is it?
Mr. Alexandrov, you might recall that in the February hearing I said Mr. Polo was sitting here and I was sitting here. There were no laptops. This was back in 1990, and he wrote things, and we discussed things constantly, section by section of the law. As you can see if you read 708, these are very precise, very short provisions, and that's natural. A civil engineer was writing this with me, a mining engineer. In February, at the hearing, I also said that what we were writing was submitted to the consideration of Mr. Sanchez Alavera, who was the minister. He was the one who decided what changes, what improvements, what things needed to be added.
So if I understand your answer correctly, the statement you made 3 times in February, I wrote the law, quote unquote, is an overstatement. You and Vice Minister Polo together participated in drafting the law, correct?
That's exactly right. He was involved, and this provision was to be sent to the minister, who also had a group of lawyers that was going to review what we were doing. We spent months together every afternoon, sitting next to each other and incorporating section by section.
So now you're saying it was not just Vice Minister Polo and yourself, but he consulted a group of lawyers, correct?
What I said at the hearing in February, and I confirm that now, is that Mr. Sanchez Alavera had a team of lawyers who came from a private sector, and they met every afternoon. Not only did they review what we were doing from the mining viewpoint, but also electricity, oil, gas, privatization.
Y usted esto lo puede.
And evidence of this is the book of Mr. Sanchez Alavera. He tells us about that with all detail.
Apologies. Yes, the minister describes that, and we'll get to that in a moment. But for now, first of all, I don't recall you saying anything in February about the participation of private lawyers. Am I misremembering?
Yes, I mentioned that, and that is also clearly stated in the book by Mr. Sanchez Alavera, where he says this law had the consensus of Congress and of the Mining Society, and those lawyers have been appointed by the Mining Society.
We're not talking about what the minister has written in his book. We're talking about the point I'm making is that you did not mention the participation of private lawyers when you testified in February, and I understand now that you're saying the statements you made then, quote unquote, I wrote the law. That was an overstatement, correct?
I've always said in February, and I say it now, that we were writing the first draft. Mr. Polo sitting here, and I was sitting right here. And starting at 4 in the afternoon, we spent the afternoons drafting the law.
Transcript, again behind tab 5, C1135, day 3, at page, I believe, 814. Line 11. This is a question by arbitrator Garibaldi. I will read it into the record.
¿Me podría decir el número?
Could you please tell me what page number in Spanish?
I'm sorry, we overlapped. In Spanish, it's 805, line 4. And it's a question to you by arbitrator Garibaldi, and he says, I have a question. Mr. Polo was a civil engineer and you are a mining engineer. Mr. Sanchez Albavero, that's the minister, what was his position? Your answer, economist. Arbitrator Garibaldi, economist. Now, the team that drafted, I'm going to ask you a question, but first I'd like to introduce it. Nothing that I say or ask should be understood in a negative light in any way. It's merely a question of fact. The team that drafted this law, did it include any lawyer or not? And your answer, the process was as follows. We would sit down for 7:08, and Mr. Polo would sit down with me. Mr. Polo, well, there were no laptops. Mr. Polo had a tablet and a pen, and he would write. Then he would call this that he had written in handwriting. He would take it and he would hand it to the secretary, who would go away to a computer and type it up. Then she would come back with a typed up version. We would make corrections, and that is what we did. That was the process, he and me. So you are saying you participated in the drafting or not? The witness, that's you, yes. Arbitrator Garibaldi, both of you did. The witness, you, yes. As I tell you, 708, if you reread it, it's a very short provision. And if you realize, or if you look carefully, the articles are very short. Very typical of the form of discourse of an engineer to use very short sentences, because it was written by a civil engineer, Mr. Polo, together with a mining engineer, myself. Arbitrator Garibaldi. So I must understand then that no lawyer participated in the drafting and not in the review of the text either. Subsequently, because it's a legislative decree, it has to go through the office of legal counsel. But from what I recall, they did not make major changes. Do you see that?
Sí.
Yes, that's here.
What you're saying here was it was just you and Vice Minister Polo. No lawyers were involved in that process of drafting. Only subsequently it had to go through the Office of Legal Counsel, but they made only minor changes. What I understand you to be saying now is that lawyers, including private lawyers, were involved in the actual drafting process. Private meaning outside lawyers. So which one is correct, Ms. Chapuis?
Usted está con...
You are confusing drafting with revision. I ratify what I said in February of this year. We both sat down to draft the law. And then, obviously, this has to go through the legal counsel office of the ministry. Some minor changes were made to the draft. Mr. Sanchez Alvarez also met with a group of lawyers who reviewed the drafts that we were preparing.
Well, the Office of the Legal Counsel is within MINEM. We understand that, and we see that in your testimony in response to Arbitrator Garibaldi. It is the first time, after 4 witness statements and 1 hearing, that you are saying that private lawyers were consulted. Did you not remember to say that in February?
I thought I had said it, but I'm not going to be able to, at this point in time, review everything. But I think I said it.
I think so, and it's not in the transcript, and if I am mistaken, I'm sure I'll be corrected by your lawyers. Now, let's see, you have tried to minimize, with all due respect, the role of Vice Minister Polo in drafting that law, and I think you repeated that in your direct examination, that he did not have the relevant experience because he had no experience with stabilization agreements. So let's go to the to see what Minister Sanchez Albavera said about the drafting of the law. And we'll start with the March Mining Forum, where then former Minister Sanchez Albavera was invited to explain the mining law that was enacted in 91. And please look at tab 20, RE 183. And if you pick up somewhere, there is a paragraph that begins with Dr. Fernandez Sanchez Albavera, and in the 6th or 7th line, he says, I feel responsible together with the engineer Cesar Polo, who was the Vice Minister of Mining. In fact, we defend the validity of Law 708 because we are the authors of that law. Do you see that?
Sí.
I do.
And then let's look at his book, former Minister Fernando Sanchez Albavera's book, which is tab 21, C311. It's pages 2730, which is the page 25 to 28 of the PDF. And it's only in Spanish, so I will read it into the record, and you'll have to bear with me. Let's focus on page 26 of the PDF in the full exhibit. The paragraph that begins with La primera dificultad. It's page 28 of the book, so the pagination is a bit off between the PDF and the book, but the paragraph is highlighted on the screen. And here, I'm not going to test everybody's ears and read it in Spanish, but the gist of it is that the minister is speaking very highly of the qualifications of Vice Minister Polo, correct?
Yes, that's true.
I'm reminded that...
Eran amigos.
They were friends.
Okay. I'm reminded that I have to test everybody's ears and read it in Spanish so that it appears in English into the record, because otherwise we don't have it in English. So, Ms. Chapuis, for the record, I'll read it in Spanish so that I can get it translated. Please bear with me.
The first difficulty that we faced was to convince two high-level officials to occupy the vice ministries of mining and energy, and a secretary general that would put things in order and would streamline as fast as possible the administration of the ministry. Cesar Polo Robillard and Ricardo Giesecke Sara Lafosse accepted the challenge of leading the vice ministries of mining and energy, respectively. The former, that is Cesar Polo, started his professional life in the Central Bank of Reserve and garnered valuable experience later on in the National Institute for Planning.
I want to move on to another paragraph, which is the bottom of page 28 of the book or page 26 of the PDF. You see it at the bottom there? Yes. César Polo formó parte de esta generación, que fue también la mía, acumulando una valiosa... Oh,
I
sorry.
do not get the translation.
Sorry about that, Madam President. Please. Cesar Polo was part of this generation, which was also my generation. He garnered valuable experience in the assessment and preparation of investment projects. He participated also in a number of international negotiations.
A little bit in that paragraph to the phrase that begins with cuando. See, cuando.
When I asked him to come to the Vice Ministry of Mining, he had spent almost 10 years of his professional life in this enormous mining project of the Centro. He knew mining problems in depth, and his experience in Centromin had convinced him that the corporate activity of the government had to change radically, and that its modernization required necessarily private sector assistance.
And then he says, los viceministerios están.
The vice ministries were in good hands, not only because of the professional quality of Giesecke and Polo, because they had shown to have that throughout a long time, but also because they had vocation of service and also they had solid models that tested any kind of challenge.
So it's correct, isn't it, that the former minister here is, to use an English, somewhat colloquial expression, singing the praises of Vice Minister Polo. Do you agree?
Yes.
Let's see what he says about you. I think it's the same document, page 28 of the full exhibit. Yeah. It's, I think, the second paragraph from top. He says, Cesar Polo.
Cesar Polo recruited Marita Chapuis, who was specialized in mining economics from the Colorado School of Mines, to assist him in the vice ministry. The same thing happened to other individuals he's listing here.
He doesn't say more. And he doesn't say anything about your contribution to drafting the law. Isn't that correct?
Yes, that's it. That's right.
Let us look at what Vice Minister Polo himself says about the process of drafting the law. And that is tab 7, C1137, that's day 5 of the February hearing. And we'll look at page in the English. In English,
in Spanish, what is
I will tell you in a moment. In English, it's 1190. It begins in 1190, and I'll go through 1190 to 1194. In the Spanish, it begins at page 1212, so 1212. I believe it's line 5 in the Spanish. But I will read it in English. So the question to Mr. Polo is, so Mr. Polo, is it fair to say that you drafted those provisions of the Ley 708 that were later incorporated in what became Title IX of the mining law? And he says yes, and some others. And then the question is, can you describe to us who the others were? And so let's look at his answer. He says, this is the area of the investment projects, which was my specialty. I think it was only myself and the minister in these matters of investment. I discussed it with the minister because we spoke the same language. Maybe there were some contributions by Maria. He later clarifies that this is you. Bernoulli did the whole part of the grids with Dr. Lastres of the private sector, the part of the grids, the part of how obligations were to be complied with, etc., etc. Then who else intervened there? Dr. Jorge Price, who is also dead now, and he was my lawyer because I'm an engineer, so I was always supported by lawyers. He was my own lawyer in 1991. And that time he was my trusted lawyer, and I named him concessions director, so I had all the trust, because in concessions there were problems. Now, who else? He talks about Oscar Bernoulli. Who else? Maybe Juan Carlos Barcelos, who also died. He was a geologist. He says, I hope I'm not leaving anybody out. Here he clarifies that when he refers to Maria, he means you. Question, Dr. Lastres came up several times. Can you explain who Dr. Lastres was? He was a top lawyer in the private mining sector. We listened to the opinions of the private mining sector, and he had important contribution in that management of concessions and to order this concession, to put it simply. Then question, did the mining society have any involvement, Sociedad de Minería? Well, under the chairmanship of the minister, we met with them several times. Many representatives came to the ministry. They discussed their point of view. Oh, and I also forgot Dr. Alfonso Rubio. May God rest his soul. I forgot about him, big mistake. He was a person who had a great deal of experience. I think he designed the part of the stability agreement of 109, which is a mistake, but and he had his experience. He explained his experience. It was difficult because he was very fast, but I took notes and I absorbed everything. Then I went home and I began to rewrite, to put down my ideas. I wrote how I thought things were, and that is the version that I presented to the minister, and then the minister approved it and supported it in the presentation to the Council of Ministers. And he talks more about this, but my question to you is this. What Vice Minister Polo describes is a much more inclusive process. He and the minister talked to the industry, the mining society, industry representatives, private lawyers representing the private companies, lawyers that he hired specifically to assist him with the drafting law. He listened to those ideas, he put them in writing, and then he presented that version to the minister, and the minister approved. And that's very different from the process that you described, that you sat down with Mr. Polo, you prepared the draft, and then eventually that draft was submitted to the legal department of MINEM. They had very few comments, and that was it. So is the testimony of Vice Minister Polo incorrect?
I told Mr. Polo, there are contracts that are like this and others that are like this. And he said, Okay, let's now call them adhesion contracts. I was sitting there, but
Can I repeat my question? My question was, sorry,
no,
Mr. Puis, my question was, I read to you the testimony of Vice Minister Polo, who describes the drafting process. And my question to you is, it's very different from your testimony and the way you describe the drafting process. So is Vice Minister Polo's testimony incorrect? Yes or no?
del testimonio del señor Polo es parcial.
Mr. Polo's testimony is partial. He did not know of any tax stability contract. He did not know how these contracts were put into practice. In Centromin, they hadn't signed a single contract. That company was in full bankruptcy, and the only thing that he was interested in was a privatization. When we sat down, I started to tell him what the problems were with the stability agreement. So did not like the contract signed under 109 because they didn't have a specific term. So he listened to me and he said, okay, what we're going to do is 15 days for the ones or two and others. And I said, contracts are different. Ones are like this and the other ones are like this. And the other ones, and the ones are like this. And he said, let's do adhesion contracts. And I said, in Chile, they start with contracts with an amount of over $50 million. So he wrote he wrote down that figure, $50 million. And what I wrote, he submitted to all these lawyers, yes, of course, but he talks about certain portions of the law. But when it talks about when they talk about the tax stability agreements, that part I drafted.
Just ask if we look. Sorry, we'll get to the provisions of the law dealing with the stabilization agreements in a moment. Let me just, while we are on it, ask you again about exhibit C1137, the testimony of Mr. Polo, Vice Minister Polo at the February hearing, tab 7 of your binder, and I believe this part in English is at page 1139, beginning line 11.
In Spanish,
I will tell you in a moment. It is 1215, line 2.
¿qué número dijo?
What number did you say?
Yeah,
In Spanish.
Spanish is 1215, line 2. Oh, and I also forgot. So, in Spanish, yes. So he says, oh, and I also forgot Dr. Alfonso Rubio. May God rest his soul. I forgot about him, big mistake. He was a person who had a great deal of experience. I think he designed the part of the stability agreement of 109. And he had his experience, he explained his experience. Did you know that Dr. Alfonso Rubio was the one who negotiated the 1998 stabilization agreement on behalf of Cerro Verde?
Yes.
That is true.
Well, that's what Mr. Reblanca told us yesterday. So I'm asking you, did you know?
Alfonso Rubio was the most famous person in the area of mine taxes.
That Dr. Alfonso Rubio negotiated the 1998 stabilization agreement on behalf of Cerro Verde.
I apologize, Mr. Alexandrov. I am going to correct you. The tax stability contracts are not negotiated. Those are adhesion contracts.
We know that in the form contract there are blanks that are to be filled in by the company. So at least to that extent, there is a role for the company to play. So I'm repeating my question. Did you know that Dr. Alfonso Rubio negotiated the 1998 stabilization agreement on behalf of Cerro Verde?
No, I did not know. And I demand that you withdraw the word negotiate.
Have your testimony. I'm not going to withdraw it, but if you want me to, if that's the reason why you hesitate to respond to my question, let me then ask it differently. Did you know that Dr. Alfonso Rubio was involved in the 1998 stabilization agreement on behalf of Cerro Verde?
Yo
I was not at the ministry in 1998. I do not know.
You're not in the ministry. I'm asking you, did you know that fact or not?
No, I did not know.
But it is significant, isn't it, that Vice Minister Polo, when drafting the mining law, consulted this very famous lawyer, as you said, who on top of that later was involved in advising Cerro Verde on the 1998 stabilization agreement. That means, doesn't it, that Vice Minister Polo drew on the best resources in Peru in drafting the law?
Mire, le voy a
I am going to answer. First, attorneys issue opinions. The decision makers are the clients or the customers. The customers were the minister and vice minister. Mr. Rubio may have presented many suggestions, but the decisions were made by the minister and the vice minister. In his book, Dr. Sanchez Alvarez clearly said that he wanted to have an impeccable mining law. So he had his right to hold consultations with counsel that he considered appropriate and the best well-known attorneys, but the decisions are made at the level of the ministry.
Can we look at your first witness statement, paragraph 21? And you say we included an additional provision to Articles 7 and 11 of Legislative Decree 708, which, as noted above, were equivalent to Articles 79 and 83 of the mining law, respectively, regarding the scope of the 10 and 15-year stability agreements. In particular, I distinctly recall that Vice Minister Polo suggested that we include a provision to make clear that the, quote, effect of the contractual benefit, close quote, that is a stability agreement's guarantee, quote, will accrue exclusively to the activities of the mining company for which the investment is made, close quote. So, contrary to what you just said a few minutes ago, you testify in writing here that Vice Minister Polo actually drafted some of the provisions relating to the stability agreements, and in particular, Article 83. Isn't that correct?
Could you repeat the question?
You said just a few minutes ago, here in your witness statement, you testify in writing that Vice Minister Polo actually drafted some of the provisions relating to stabilization agreements in the law, and in particular, Article 83. Isn't that correct?
¿Podrían poner
Could you please show me Article 83 on the screen?
Give us a moment, Mr. Chapuis, and we'll do it.
o quizás mejor el artículo 11 de la 708?
You say there, I'm sorry.
Or 11 of 708.
Well, you are saying in your witness statement that Article 8 is equivalent to Article 83 of the mining law, so I think we'll put Article 83 of the mining law on the screen.
Esa es la versión.
That is the original version without changes, correct?
It's Article 83.
Ok, leamos juntos.
Let us read together. That article starts by indicating who will have the right to enter into contracts. And we refer to a figure of $20 million for the start of any of the activities, mining activities, that is. In the second one, we are already referring to the existing companies, and there we increase the requirement to 50 million. Then we move on to the third paragraph, and we state, shall also have the right to access these contracts the persons who make investments of $50 million in state-owned companies that are subject to the privatization process as stated under Decree Law 674. And then we move on to the fourth paragraph, whereby we clarify, because Engineer Polo clarified that Centromin has factories. This benefit may not be, it says Centromin has factories, and this benefit may not be given to non-mining activities of the Centromin holding. I should clarify that Centromin is the only mining company that had factories. Tintaya did not have this type of mining activities.
The effect of the contractual benefit shall apply exclusively to the activities of the mining company in whose favor the investment is made. And in Spanish, you can read it better than I can. El efecto del beneficio contractual.
The effect of the contractual benefit shall apply exclusively to the activities of the mining company in whose favor the investment is made.
You have that in front of you. And what you're saying in paragraph 21 of the witness statement, you distinctly recall, I'm quoting, I distinctly recall that Vice Minister Polo suggested that we include a provision to make clear that, quote, the effect of the contractual benefit, the same words as in the law, that is, a stability agreement's guarantee, quote again, will accrue exclusively to the activities of the mining company for which the investment is made. That is again a quote from the provision of the law. So you distinctly remember that it was Vice Minister Polo who suggested including this particular language, the fourth paragraph of Article 83, in the mining law, correct?
Sí,
Yes, because both of us were sitting there. We were talking about the mining companies, state-run mining companies, and he recalls that Centromin has factories. It was the only mining company owned by the state that had factories. The other ones,
Are not part of my question.
Can you let her finish the question? She was just in the middle of the explanation.
I'm
She just
sorry,
had
but
like
she's
one
not
sentence.
answering my questions. And
She was answering your
no,
question.
she wasn't. I asked her whether she confirms her testimony that she distinctly remembers that that provision was included in Article 83 by Vice Minister Polo. The factories of Centromin have nothing to do with that. Or if they do, you take this up on redirect.
podríamos volver a la
can we go back to Article 83, 11 of 708?
Article 83, and if it's not, Council will take you to
Yo
Article
he
11.
explicado
Sorry.
cómo hicimos la
I have explained how we drafted this. We gave the mining companies that were in the privatization process. Polo finished writing this and said the holding Centromin has factories. They cannot receive, those factories may not receive a tax stabilization contract. So he wrote, this is only going to be for mining activities. And I have explained that the tax contracts were only received by the mining sector in Peru. After that time, the Ministry of Economy and Finance changed the criterion and included stability for all of the sectors. But up to that point in time, only mining. And I already told you that as of November 8th of 1890, Peru is entering stability contracts with the mining companies.
I was simply asking you to confirm your testimony in writing, which is that it was Vice Minister Polo who included this particular provision in Article 83 of the mining law. Can you please confirm that, or if not, you explain why your testimony today differs from your testimony in your witness statement?
él termina de
He finished writing and he told me Centromin has factories. He looked at me and I didn't know that Centromin had factories.
Who proposed that this provision be included in Article 83 of the mining law, yes or no?
sí, como le digo, sucede.
Yes, as I mentioned before, he told me Centromin has factories. We need to correct this with that fourth paragraph.
Can we look at tab 20, is C395? I'm sorry, tab 26, which is C398. So, Ms. Chapuis, to give you some background, you'll remember the question of the application of the non-distributed profits of Cerro Verde to invest in part tax-free into a new investment project. And they sent you 2 letters in July, and you responded to both letters on September 8. And this is one of the 2 letters that I want us to look at together. And first I want to establish that this is a legal opinion or a legal report signed by 2 lawyers, and then it's signed by you. You find it in order and
Sí,
authorize that this report be sent to Cerro Verde. You see that?
Sí.
Yes.
And of course, your signature means you agree with the legal report.
Sí.
Yes.
Okay, so can you look at paragraph 4?
Sí.
Yes.
Where the report says the application of the stabilized regime is granted to the Cerro Verde leaching project and not to the company. Do you see that?
Yes. The Cerro Verde leaching project is a name, and that was the name of the stabilization contract that had been signed. This is in upper case.
And this refers to the Cerro Verde leaching project. Your testimony now is that this means the 1998 stabilization agreement. Is that right?
Even though it may sound paradoxical, every contract had a name, such as Cajamarquilla, Unisur, Communication, and this contract with Cerro Verde, and the reason why we are here, was called Cerro Verde Leaching Project. That was the name of the contract.
Statement, paragraph 42. You see that you're saying in the second report, that is the document we're looking at, we addressed other questions that Cerro Verde had asked and stated that, quote, the application of the stabilized regime is granted to the Cerro Verde leaching project and not to the company. You refer to that report in a footnote, so we know it's the same document. And then you say, although in hindsight, this choice of words is not entirely clear in expressing our conclusion, what we meant, referring to the language of the stability agreement itself uses, was that the scope of the stability applies to Cerro Verde mining unit and not to the company as such. That is, not to Cerro Verde. For example, if they had other mining units, they would not have enjoyed stability guarantees. You see that statement you've made in your first witness statement.
Los contratos de estabilidad tributaria.
The tax stability contract always made reference to a mining unit.
Whether you see your written
Yo estoy
testimony.
leyendo eso y
I'm reading that, and at that point in time, Cerro Verde did not have another mining unit. They had one mining unit, Cerro Verde, that entailed one mining concession and one beneficiation concession at Annex 1 of Article 3.
Here that in hindsight the choice of words is not entirely clear in expressing your conclusion, correct?
Yes, they should have, but I understand it, but they could have said the tax stability contract named Cerro Verde leaching project. But it is understood. I think it is understood. And it was part of the jargon that we used within the ministry.
What words would you have used to make this clear?
esta se utiliza
a jargon typical of the ministries used. The stabilization contracts were called by their name, Casa Marquilla and others, whatever that was. We call those contracts Casa Marquilla and others, or Milpo Expansion, San Jose, Carachubo, and this was the Cerro Verde leaching project.
The choice of words is not entirely clear in expressing our conclusion. So I'm asking you in hindsight, what choice of words, now that you've seen that, what is the choice of words that would be entirely clear? What would you have said to make this entirely clear?
Bueno,
Well, that's the reason why we're here. That is, that jargon, that name given to a contract, most of you are lawyers, should seem strange that contracts have a name. But yes, it did have a name. And in the case of this contract, this Cerro Verde contract that convenes us here, it was Cerro Verde Leaching Project.
Understand that, but my question is a bit more specific than that. You yourself say in your witness statement, the choice of words in paragraph 4 of this document is not entirely clear in expressing our conclusion. And I'm asking you, if you were drafting this today, what words would you choose to make your conclusion entirely clear?
habría escrito, primeramente yo hubiera cambiado esa forma de denominar.
I apologize. I would have changed that way to call the contracts by using a name. Casa Marquilla and others, expansion, I would have called it with a number. And when writing this, I would have answered, in accordance with your tax stability contract number 002224, whatever that number would be, and I would continue with my sentence.
You have the 1998 stabilization agreement, and it is what it is. You cannot go and change it, cannot go back and change it. And we've established that it's up to the investor to fill in the blank in the model contract. And my question is not about what you would have changed in the 1998 stabilization agreement. My question is specific with respect to paragraph 4. And I'm asking you because you've said in your testimony this choice of words is not entirely clear in expressing our conclusion. And I'm asking you, if you were drafting paragraph 4 today, what words would you have chosen to express your conclusion so that it is entirely clear?
Bueno, le habría añadido lo
I would have added what I said here. The scope of stability applies to the mining unit rather than to the company itself.
You would have said the application of the stabilized regime applies to the mining unit rather than to the company itself. Well, let's look at before we look at the next document, you testify that you always believed that the 1998 stabilization agreement applied to the entire Cerro Verde mining unit. Why didn't you say so in paragraph 4? I mean, this text was not something written on the spur of the moment. The letter to which you were responding was sent to you in early July. Actually, I think it was July 8th. And you respond on September 8th, so 2 months later. It is prepared by legal department and signed by 2 senior lawyers. So it's not a text that is prepared in haste and somehow not well thought over. And you reviewed it carefully and found it suitable and in order. So why didn't you at the time say the application of the stabilized regime is granted to Cerro Verde's mining unit and not to the company?
Porque
Because it was an adhesion contract. What does it mean? It means that this contract, the text with the blanks, the template with the blanks, was published in a supreme decree. Then the only variation was the name of the contract and Annex 1, where we included the concessions. Then my counsel simply said, you have signed a contract. What contract? All contracts were the same. So, but this contract is called Cerro Verde Leaching Project, and it applies to the Cerro Verde mining unit that had a mining concession and a beneficiation concession. And what is the regime? The tax regime, the one that is thereby established. So it was clear to them and also to me, because since it was an adhesion contract, it was clear there was no additional clause, no specific article, nothing. All of the contracts were the same.
Alexandrov, may I step in for a second on this adhesion contract? Have you been involved in the development of this model stability agreement, in the development of this adhesion contract? I think we have on the record a model stability agreement of 1994. It's exhibit CE 778. Have you developed this adhesion contract, or are you familiar with it?
We drafted the law, and I told Polo, there are some stability contracts under 109 that are like this, and others are like this. Then Polo told me, to avoid problems, to avoid to be accused of corruption, let us have an adhesion contract. That was 1991, 1992. I left in February 1993, and I understand that in 1994, before the signing of the Cyprus purchase, Supreme Decree was published with the text of the contracts, and I did not participate. I was no longer with the ministry. However, when I reviewed it, that text is quite similar to the text of the stability contract for Tintaya, where I worked for 3 years, and that was my Bible with the inspectors of the ministry.
Look to this exhibit CE 778, which is this 1994 model adhesion contract, and you explained to me whether I read it correctly or not, and now what is your view on that? I understand that there are some clauses there on which the mining company has to insert wording. For example, clause 3. Is my understanding correct?
Yes, but if you're referring, and let's take it slowly, what the company has to insert is not very relevant information. For example, I don't know, what is the article?
For example, about clause 3, but also clause 1.3, 1.4 about the background. So I understand there are a couple of provisions that need to be filled in by the applicant, the mining company. Is this correct, or who fills in the form?
Sí, pero sí,
Yes. Actually, I've never been involved, but the company fills it out and the ministry reviews it. But that's background. So it talks a little bit about what the project's about, a technical description.
Yeah, but for me, in particular, if we look to paragraph 1.1, my understanding was that the company could choose and now what they applied for. So whether it was in relation to an operational startup or investment in, and also whether it's concessions consisting of or administrative units. So my impression was, when reading these options, that it was for the mining company to decide for what it applied, and so it could choose. That's only my understanding, and I asked you as a witness and expert at the time how you read it, that the mining company could make a choice whether they applied for stability for an administrative unit, for a specific whole concession, or for a specific investment.
no.
No, the tax stability agreement was for all of the concessions indicated in that Annex 1, all of them. And then I can explain to you why. Because mining is a sector that deals with or manages natural resources. So today you are extracting copper, and no one can say that within 2 years you mightn't change all the technology you're using and you start extracting rare earth metals at Cerro Verde. One could not assure that that would not be possible. Now, if you've read the Financial Times 2 days ago, Germany is going to reopen all of its mines to process them, seeking rare earth metals because they don't want to be subject to China and Russia. That came out in the Financial Times 3 days ago. So, we had a stability agreement that covered the entire concession, and we issued it for 15 years, and one could not attach it to a specific investment. As I was saying, the investments covered all types of investments that the company might make over a 15-year period in that concession that had been put there as Annex 3 in all of the investments. Excuse me, you're saying, when you say concession, you're referring to a specific geographic area in order to understand concession? Yes, it is a geographic area. In mining, if you review the whole law, everything refers to concessions. And if you review Article 19 of Decree Law 708, and it clearly says all of the activities in the mining sector are carried out through concessions. Now, what you just said, if I understood properly, they might get a different ore and they'd be protected as well. If it's within the time frame, yes, and it has happened. We have the largest tin mine. Before it was copper. We had a coal mine, and then gold was extracted from it afterwards. And as I say, at present, Germany is going to go and get rare earths from all the mines it has. You can read that in the Financial Times. And the stability has not been called into question despite changing from one ore to another? No, it is not called into question. This is 15 years, 15 years. Just because I switched, I'm now getting rare earths, I want additional time? No.
So just to come back to my original question, we will have other witnesses and experts on that question, so just I want to understand how you understand it. So your testimony is that this adhesion contract does not provide for any options by the mining company for what specific investment it applies stability, but it automatically and mandatorily extends to the entire concession. So whatever will be invested at whatever point in time during the 15 years is covered. This is your testimony.
Sí.
Yes, you have to recall two things. Mining is the second most capital-intensive activity after aviation. Changes are being made. Technological changes are being made constantly. Large-scale investments are being made constantly. Second, it is an industry that's a price-taking industry. If we take Freeport, what's the price of copper in November? Well, one can't answer that. So, since it is an activity involving natural resources that you're extracting, you have another system or another approach. These mines in Germany, in Schwarzwald, in the Black Forest, were extracting feldspar, and now it seems that they're flooded, they're closed, and now there's going to be reopened to look for something else, which is rare earths, for which there is a sophisticated processing plant and totally different one from what is situated at those mines. That's why I say these contracts based on the mining law covered the entirety of the concession for 15 years for all investments, technologies, changes, if they found coal, if they found gold, if they found molybdenum, if they found whatever. Cerro Verde is a copper deposit that's very large. So at the top there are 30-meter layers of oxides, and then you go further down and you find transitional material. But below that you have 1 kilometer of primary sulfides. 1 kilometer. Cerro Verde is now one of the largest mines in the world, and it plans to close in 2040 or something like that. A time was taken to start it up, to get it operating, because it didn't have water or electricity, as I noted. It was totally discarded by Phelps Dodge in 1993. It didn't have water. It's in the middle of the desert. If you are somewhat familiar with northern Chile, where the copper mining companies are, this is the Atacama Desert, which goes north and reaches Cerro Verde. So Cerro Verde is a desert. And the water is brought from a treatment plant of for wastewater from the city of Arequipa. That's the solution they found.
Just to verify that I properly and I understand you. So your position is, when we look at this adhesion contract, in the moment the company decides to enter into this adhesion contract, then it is stuck with it, and then it freezes, at the time it becomes applicable it freezes the regime for the company, whatever it will do in the future, within 15 years. So even if the tax regime becomes more favorable over time and the company wishes to make a new huge investment, it would be stuck with the old regime because it's not optional. It's just fixed in stone in the moment you enter into it, regardless of how you define your investment. It's just for the concession. This is your testimony.
Yes. And I could narrate the cases to you in which companies have come to us and they have said, I'm going to make another large investment and I want to resolve this this 5-year contract or terminate this 5-year contract and extend it for 15 years or have a new one for 15 years. And we've told them, no, you have your tax stability agreement. There is no termination or succession of contracts.
Thank you. This answers my question for the moment. Sorry for the interruption.
Thank you, Madam President. And I'll continue with the reinvestment program, but since I had this line of questions, I will follow up on the question of the President of the Tribunal while we're still on this document, which is the model stabilization agreement. And it is, if you want to look at your binder, it's tab 28. You can look at the screen of your binder. And I want to look at clause 4, the 4th clause. It talks about the investment plan, and it says, the investment plan included in the feasibility study referred to in Article 85 of the mining law includes in detail the works, labor, and purchases necessary for the commissioning or startup of the production process or the actual operation of the project, and also defines the benefit or the approximate additional production volume to be obtained. The investment plan duly approved by the General Mining Bureau for the purpose of signing this instrument is an integral part of it as Annex 2. The total term for the accomplishment of the investment plan is blank months, which will expire on blank. If any change is required, this may be done regarding the works and tasks yet to be accomplished, provided the final purpose of the investment plan is not affected, and also provided that the owner of the mining company first files with the General Mining Bureau the application for approval of these amendments and or the expansions, and also without prejudice to approval by the General Mining Bureau, so that the amendments and or expansions made will be validated and included in the investment plan. And then 4.3 says, among the main works and tasks contained in the investment plan are the following. There is 1, 2, 3, 4, 5, 6, 7. So I have several questions on that. One, you kept saying this is an adhesion contract, there is nothing, you even objected, you asked me to withdraw the word negotiate, but we see here is that this contract, this stabilization agreement, requires that the company submit a fairly detailed investment plan that is to be approved. So there is something, at least here, to negotiate, because the plan may not be approved, or the General Directorate of Mining may request changes to the plan. And it requires a fairly detailed description of the works and the tasks to be performed. And my second question is, if, as you say, once you enter, let's say Cerro Verde enters into a stabilization agreement as it did in 1998, and it covers concession, the mining unit, why does it need to prepare such a detailed investment plan? All it needs to do is say, prove with documents that it had made the minimum investment to qualify, and then it gets a stabilization agreement that covers all of its mining unit, whatever investment plans there are there now or in the future. Why is it necessary to present such a detailed investment plan that needs to be approved by what I assume is your directorate? It frankly makes no sense that this requirement is there if once you make the minimum investment required, you have an adhesion contract that automatically applies to the whole mining unit.
Rechazo el calificado.
I reject the description detailed, and I would ask you to show the tax stability agreement of Cerro Verde and see what was included in the investment plan.
That, but you know that the feasibility study is attached in an integral part of that contract, and it is quite voluminous. I don't think we have time to review the whole feasibility study. Do you want to see just section 4?
La sesión.
Section 4, well, let's put it up. The feasibility study, to begin with, well, you know that the feasibility study has a 60-70% probability. Second, what is presented here is not detailed. It's an investment of $130 million. As you can imagine, not all of the studies for an investment of $130 million are put here. So I'd like to see what was put here. Would you be able to show that?
Well, I never said all the studies for an investment of 130 million are put here, but there is a feasibility study in this particular case, a feasibility study that is an integral part of the 1998 stabilization agreement, and it is, I'll check in a moment how many pages. It is
No, puede.
You could put this up and you'll realize
of the 1998 stabilization agreement, what we cannot put because it's hundreds of pages is the feasibility study.
Mientras
Yes, give us a moment.
Mientras
We'll do
usted
that.
While you find the page, let me explain. This is copper porphyry, and up above there is our oxides in one part. And I've already said that this layer up above is only 30 meters deep. There's then transitional ore 50 meters, but here below it are the primary sulfides, which are 1 kilometer deep. So the project economics is you have to remove what is up above in order to reach this immense volume that is 1 kilometer deep where the primary sulfides are. But Cerro Verde began to remove these oxides. Those oxides had a very high copper content. You can imagine that these are machines that are removing the land. It's very costly, but then Cerro Verde takes those oxides and processes them in a plant dedicated to oxides, the leaching plant, and sells the copper.
We have on the screen section 4 of the 1998 stabilization agreement.
Yo quisiera el plan de
I'd like to see, there's the investment plan and then there's the list of the investments, which I'd like to see.
See? 4 point.
Había otro que estaba con.
There was another one that had some numbers.
Así. Bueno.
I'm not sure what you want to see, so tell us what you want to see.
Está,
We'll show it
está
to you.
ahí.
This is section 4.
Si usted me dice,
If you tell me the page or where the contract is here, I can tell you.
It is not in your binder. The 1998 stabilization. Oh, sorry. Yeah, I thought this was the model. Tab 29. And clause 4 that you wanted to see is on page, it begins on page 6.
bueno, para
Well, to begin with, that feasibility study is reviewed and the DGM for a maximum period of 3 months, and there's positive administrative silence. And here under 4.3 it says, among the main works. So among the main works is the leaching system, the installation and infrastructure of the mine, installation to increase the crushing, expansion of the processing plant, construction, studies, construction, and drainage. Because it's as I've explained. They begin to extract the oxides. They process them by leaching, but this is also a stripping away to get to the layer of primary sulfides, which is immense.
That is not what I'm asking you. If you look at this clause 4.1, at the very end, it says that the investment plan is an integral part of the stabilization agreement as Annex 2. Do you see that?
Yes, but we need the company to, if we were going to sign a 15-year stability agreement, we needed the company to present a study of at least something greater than 50 million that it was going to do. And this study presented by Cerro Verde was of works already executed. And if we examine that, any mining engineer will realize that this was a stage to seek the primary sulfides.
If you need the feasibility study only to demonstrate that the company has invested 50 million, why do you need the whole feasibility study to be an integral part of the agreement, and why do you need the description of the works in the subsequent subsections of clause 4? All you need, if your testimony is correct, all you need is proof that the company has invested 50 million, and then you grant a stabilization agreement for the whole mining unit. You're not interested in whether it is, according to your testimony, whether it's a leaching project or a stabilization plant or whatever it is. As far as they invest 50 million in the mining unit is what your testimony means, then they have that mining unit stabilized for this investment and any future investment. Why would you need a detailed description of what the investment is? It could be any investment in the mining unit that you refer to, as far as it is 50 million or more.
In part, you're right. One could make any investment. But for our purposes of the work of inspection of the ministry, we had to have at least a study covering the initial investment that qualifies so as to then move on to the signing of the agreement. This study is submitted, it's analyzed, and then subsequently there are officials of the ministry who go to the mine and check. You said here that a feasibility study was going to be undertaken for the sulfide plant. Where is that study? Here. You said that you were going to strip the top or clear the top layers with 40 trucks and so forth. Where's that? Okay, it's here. You said you were going to set up a water plant. Where's that? It's there. So everything is reviewed. We have to have something on paper so that the person is going to review it. Well, where is it? You made a investment of 520 million. Where is it? Or 50 or 20 million. Where is it? 3 days, everything is reviewed.
Feasibility study. I told you the feasibility study is over 100 pages. In fact, it's 223 pages. This particular feasibility study that became.
Y yo le dije que ese estudio.
Sorry,
And I told you that it is 60% credible because it's not a detailed study.
sorry. I was just correcting the number that I gave you. And just for the record, the resubmitted feasibility study is C009. Is it your testimony that the investor, in this case Cerro Verde, could have made any investment in the mining unit that exceeded the minimum amount required to qualify for a stabilization agreement, and then automatically all the mining unit and all present and future mining activities in the mining unit would be stabilized? Is that your testimony?
Yes, once we verify that the works were there and that minimum amount of investment was carried out, then one proceeds to grant them a contract that is stabilized for 15 years for all of the investments they might make.
220 pages were necessary to demonstrate that the minimum investment was made. Is that your testimony?
That 223-page study was reviewed, and there was a 90-day review period, and there was the rule of positive administrative silence, plus the mine would be visited.
The question was, is it your testimony that the only purpose of this feasibility study was to demonstrate that the minimum investment required for the company to qualify for a stabilization agreement was made?
Exactly. For the studies or 10-year agreements, a feasibility study was not required. They were simply required to submit an investment plan.
So, Mr. Puis, to go back to where we were before we engaged in this line of questions about the stabilization agreement, we were talking about the legal opinion of September 8, 2023 on the, I'll point you to the document. I was just giving you the context of where we were. We looked at the legal opinion, the second one, of September 8, 2023, and you and I had a short discussion about, in hindsight, what you would have improved, if anything, to make the language clearer. I now want to show you, well, just to give you a bit more context. So after those two inquiries of July 2023 and the two legal opinions issued by the General Directorate of Mining, in January of 2004, Cerro Verde applies for the profit reinvestment benefit. And that application is approved by a resolution. The document reference is C23, December of 2004, and it's behind tab 27 of your binder. And I will be asking you questions about that document. You approved that resolution, didn't you?
Sí.
I did.
Let's look at Article 1. Article 1 talks about the investment program, that is the concentrator plant. It refers to the amount to be invested. It refers to the period of implementation. And it says, the last two lines, funded with retained earnings from the same financial years, which must be exclusively generated by the Cerro Verde leaching project. So in February, I asked you, in hindsight, would you make any changes to that language to make it clearer? And your answer was, I cannot change the language because this is the standard language. The language is standard. Do you confirm that testimony? Now, in hindsight, you would not have changed anything in that language.
Could you just, for the record, provide a quote to the where in the transcript you said that?
Can you look at tab 5? C1135. That's day 3. In English, it's 834.
Lo que yo
In
dije,
Spanish, sorry.
lo que yo dije,
In Spanish, do you have the Spanish? Council wanted me to show you the language. So Spanish, it's 826.15, carrying over to 827. And your answer, which begins in the English text on line 9, is,
en Spanish,
it's on the screen.
lo que yo le
What I told you,
Let me make sure you find the language. Line 15 in the Spanish. You can see it on the screen to orient yourself if you want. In English, you say, I cannot change the language because this is the standard language. Language is standard. And I assure Council that I faithfully quoted before I showed the transcript. Do you confirm that testimony?
I confirm what page 827 says, that this ministerial resolution has to be read by first reading Article 2, because Article 2 is the important article. It says here that this ministerial resolution has to be sent to SUNAT. And it says here that the reinvestment program is approved. I don't see the copy here, submitted by Sociedad Minera Cerro Verde, and it says here, funded with retained earnings from the same financial years, which must be exclusively generated by whom? By the Cerro Verde leaching project. What is that? And it's capitalized. That is in the tax stabilization agreement. This tax situation exists in 2004, but it was repealed since 2000. But why is it being given to it? Because the government, as we said, is going to respect the tax stabilization agreement. And when they signed this contract, they were allowed to reinvest their profits in the same units to extend production in the same stabilized unit and in none other.
So your testimony is, first, you wouldn't have changed anything you point to Article 2 because this resolution must be sent to SUNAT. And so your evidence is that when SUNAT reads the phrase, when the SUNAT officials read the phrase, funded with retained earnings from the same financial years, which must be exclusively generated by the Cerro Verde leaching project, SUNAT will understand this to mean which must be exclusively generated by the Cerro Verde mining unit. Is that your evidence?
Sir,
And then
Cuando se suscribe,
when a stability contract is entered into, I'm sorry, Madam President. I'm sorry.
Sorry, Mr. We cannot, we have no interpretation and we cannot.
Sorry, yeah,
So
well,
maybe you repeat the question and then you repeat the answer.
I apologize for interrupting, but I have a strong incentive to complete as soon as possible, and I don't mind the witness giving a brief explanation after she answers my question, but I'd like first to hear the answer. And my question was, is it your evidence that when SUNAT officials read the language that the retained earnings must be exclusively generated by the Cerro Verde leaching project, is it your evidence that they will understand this to mean that the retained earnings must be exclusively generated by the Cerro Verde mining unit?
When a tax stabilization agreement is entered into, in this case it is called the Cerro Verde leaching project, SUNAT receives a copy of it. In this resolution, what we are saying in the resolved section, we're saying to the SUNAT, okay, we are granting these reinvestment benefit that had been repealed in the past. It was repealed in 2000, but we're here in 2004. We're going to give this to Cerro Verde. Why? Because Cerro Verde has a stabilization agreement that is called the Cerro Verde leaching project. We are going to grant it to it because of that reason and because of the fact that that profit reinvestment, and as you know, when you have a stabilized unit that creates income, you have a tax deductible and they can reserve that income for 4 years to reinvest in the same stabilized mining unit. So we're saying to SUNAT, they had that tax deductible, and that is why we are approving this.
To the microphone. So, in brief, Ms. Chapuis, what you're saying is SUNAT or anybody who has the 1998 stabilization agreement and sees this language will understand that the profits must be generated exclusively from the Cerro Verde mining unit when they see the language that says exclusively from the Cerro Verde leaching project. If that is the case, then my question is, I have two questions. My first question is, why didn't you just say the Cerro Verde mining unit?
Porque entre
Because between the ministry and SUNAT, we speak on the basis of the names of the contracts signed. This was a provision that had been repealed in 2000, and we're at December 2004 here. SUNAT had a copy of the stabilization agreement that it received in 96 or 98. And we told SUNAT, okay, today we are granting this tax benefit to Cerro Verde because those profits that are going to be reinvested and retained, they are a consequence of the Cerro Verde leaching project, the contract known as Cerro Verde leaching project, that it is made up of the Cerro Verde mining unit.
Go to tab 29 in your binder, and that is the stabilization agreement C12. I'm looking at the title of the contract or the name of the contract. It's not the Cerro Verde leaching project. It says contract of guarantees and investment promotion measures granted by the Peruvian state in favor of Sociedad Minera Cerro Verde. I understand that to be the title of the contract. Am I wrong?
Déjeme leer.
Let me read it, and then I'm going to try to find it. Just a couple of minutes, please.
But we are a little bit pressed for time, so just look at the first page and the title of the contract. You say the name of the contract is the Cerro Verde leaching project, and I'm looking at the contract and I see a name that says something different, which is contract of guarantees and investment promotion measures. Isn't that the name of the contract? Mr. Pues, can you please answer the question because we are pressed for time?
Disculpe,
What was your question, please?
Please look at page 1. The name of the contract is Contract of Guarantees and Investment Promotion Measures granted by the Peruvian state in favor of Sociedad Minera Cerro Verde. The name of the contract is not what you refer to in the resolution, which is the Cerro Verde leaching project. Can you confirm, please, when you read this, that this language is there? We don't have time for you to read the whole contract. If you have a question, let me know. We'll point you to a provision. But I'm sorry, we don't have time for you to review the stabilization agreement, which you've testified you know upside down.
Mr. Alexandrov, if we had signed this in accordance with the 1890 law, this contract would be called Contract of Tax Immutability. So here they talk about contract of guarantees, contract of tax immutability, tax guarantee contract. All of this is the same.
One of the ministerial resolution, tab 27C23, the retained earnings which must be exclusively generated by the Cerro Verde leaching project, and you said everybody would understand that by the Cerro Verde leaching project you meant the Cerro Verde mining unit. In that case, why the word exclusively? Everything within the mining unit is covered by the stabilization agreement, isn't it, according to your testimony?
Mr. Alexandrov, I found the figures that I was looking for. I was speaking to you about figures, and I've found it.
So we can perhaps put it on the screen, which page or which clause of the contract are you on?
Anexo número 2. Anexo número 2.
I'm looking at Annex 2.
And what did you want to say about it?
Este anexo 2 prueba lo que yo estaba diciendo, que en este proyecto de factibilidad que se adjunta,
This, I'm sorry. What I was saying is that in this Exhibit 2, well, this shows what I was saying, that in this project, we had mine equipment for over $40 million. Why? Because there was a clearing up. They were stripping everything. They were stripping all of the oxides to get to the great deposit of primary sulfides that has 1 kilometer, that goes 1 kilometer deep. And here we look at the figures, right? We look at crushing and all the big figures. And this is the feasibility study of the mill, it says here. No, it is the concentrator feasibility study. The translation is wrong. And also it talks about exploration. It's a big figure as well. If we look at the feasibility study, and from a geological viewpoint, we see that it clearly says that we are going to go to the primary sulfides area. Now I'm going to answer your question, but please ask the question again, sir.
Well, my question was on Article 1 of the resolution approving the... Thank you for that clarification, by the way. So my question went back to Article 1 of the ministerial resolution that approved the profit reinvestment program. And your testimony was that when the resolution said the profits must be exclusively generated by the Cerro Verde leaching project, anybody who had the 1998 stabilization agreement would know that this means the profits exclusively generated by the Cerro Verde mining unit. So I'm asking you then, why the word exclusively if we're talking about Cerro Verde's mining unit as a whole and all the profits generated by the mining unit?
Because we are telling Sunat this. We're saying, Sunat, we're not allowing this company to bring in income that will benefit from this tax benefit from a concession that is not stabilized. This was a tax benefit, a tax regulation that had been repealed. So to avoid problems with Sunat, we specified this to Sunat. We said this is non-distributed profits that are going to come from a stabilization agreement called Cerro Verde Leaching Project.
Your testimony is that by saying exclusively generated by...
Sorry for the interruption, but we are just wondering whether your intention is to finish with Ms. Chapuis today?
Can I ask just this last question, which is the end of my line of questions, and then I want to talk to you about going... But I'm hoping with this last question to complete this line of questions. Ms. Chapuis, so to summarize your evidence, when one reads the words exclusively generated by the Cerro Verde leaching project, one would understand this to mean exclusively generated by the Cerro Verde concessions or mining unit and not any other concessions or any other mining units. Is that your testimony?
Cerro Verde had this benefit in 2004. It was a provision that was repealed, but since Cerro Verde had a stabilization agreement called Cerro Verde leaching project, then it had this benefit. That mining unit generated income, and that income was going to be used. If Cerro Verde had had another mining unit, that income would not have received that tax benefit. That is what we wanted to say in these two articles.
They had other plants in this mining unit, in this concession. Would the non-distributed profits from all those other plants, other than the leaching project, would they also be reinvested in the construction of the concentrator plant free of tax?
I don't understand your question. Could you please repeat it?
In this mining unit, in the concessions that we are talking about that are described in Annex 1 of the 1998 Stabilization Agreement, Cerro Verde had a leaching plant. The profits from that leaching plant could be reinvested without tax into the construction of the concentrator plant. And I'm asking you, based on your testimony, if there is, in addition to the leaching plant, if there was another plant operating in that, what you refer to, a mining unit, in that concession, would the non-distributed profits from that other plant, could they also be reinvested into the concentrator plant tax-free?
Yes, I'm going to explain. All of this mining unit, in the state it's known as mine site, was stabilized. They were producing in a leaching plant. They were stripping everything, stripping all the top layers to get to the primary sulfides. If at that time, let's imagine, they had placed a plant to recover rare earths, that plant that was treating the stabilized mineral and that was located within these stabilized concessions had been stabilized, would have been stabilized. And the benefit would have been received by the leaching plant and by the rare earths plant.
Even though that other plant would not be mentioned in the feasibility study that is an integral part of the agreement, it would not be mentioned in clause 4 of the agreement or any other clause of the agreement, correct?
Repeat your question, please.
The proceeds from that other plant in the same concession would benefit from the 1998 Stabilization Agreement, you say, even though that other plant is not covered by the feasibility study that is an integral part of the 1998 Stabilization Agreement, and that investment in that other plant is not mentioned anywhere in the 1998 Stabilization Agreement, correct?
Mr. Alexandrov, throughout this afternoon, I have tried for you, lawyers, to understand something from me, the mining engineer.
You say first yes or no and then explain. It will help us a lot to understand your testimony.
No, primero ustedes tienen que...
First, you need to understand what I'm saying. We're talking about natural resources. Today, I am taking out oxides. Then, of course, they run out. Oxides run out. I'm taking these out of a hole. And then it's better to have a concentrator plant. So I start getting things out through the concentrator plant. And then the price of lithium shoots up. And then I have lithium. And I said, okay, let's set up a lithium plant. And I mine lithium. That is how mining works. I want you to understand this. These contracts covered all types of investments, copper, rare earths, lithium, whatever you want for 15 years. And then you can place any kind of plant you want during 15 days, but not a day over 15 years. 15 years. It's not like this little plant and then rare earths, no, lithium, no. These are all the plants. Why? Because these are beneficiation plants. I drill a hole. I have no power whatsoever on the prices set by London. Today, copper is $4 and lithium $20,000. I can say, okay, lithium will go up to 80,000. I'm going to say, okay, let's mine lithium, and I can set up a lithium plant here. That is what mining is. That is how mining works. Also, mining works with great investments. It is very capital intensive.
Out of time. I understand your position, and I'm asking you, and that your testimony is that this is the case even though this other investment is not covered by the feasibility study, which is an integral part of the agreement and is nowhere mentioned in the agreement. And you can just confirm that this is the case even though the agreement doesn't say anywhere, including in the feasibility study, anything about this other investment. Am I correct in understanding your testimony?
The feasibility study indicates very clearly all of the geology matters. They say we're going to the primary sulfides area, and then during the mining stage, they say very clearly, okay, we're going to conduct pushbacks this year and this year and this year in Cerro Verde, etc.
An answer to my question. My question was,
bueno,
no, it's not.
Yes, I am answering your question.
Ingeniero de minas, yo leo pushbacks y eso significa que la mina se amplía así porque nos vamos para abajo.
It's not an answer to my question.
I don't get a translation.
Yeah, I want to repeat my question. My question was, if this other investment is not covered by the feasibility study and is nowhere mentioned in the stabilization agreement, is it still your view that this other investment, because it is in the same concession or the same mining unit, is covered by the stabilization agreement?
What you're saying is not true. The feasibility study mentions the sulfide project. I'm explaining the geology.
Question.
Le estoy explicando y usted no quiere explicar.
I am explaining this to you. There are pushbacks that are included in the mining plan. I'm explaining that when it comes to power and energy, well, it says clearly that we need 800 liters per second for the sulfides, and we only have a license for water for 100 meters per second. We don't have water. And then you are saying that in the feasibility study, no mention is made to the sulfides project. Yes, mention is made to the sulfides project.
Our evidence is that the concentrator plant is covered by the 1998 stabilization agreement because there is a reference to it in the 1996 feasibility study. Do I understand you correctly?
Estaba ese.
The reference of the primate sulfide studies was found in 1979 by Parsons. So we always knew, and you know very well, that Cerro Verde already had a concentrator for 3,000 tons back from 1974. So we always knew it was not something that came out of thin air.
Because of that, it was because it was always known, you say, that there will be a
Usted no me
concentrator.
puede decir que no está nombrado.
But you cannot tell me that it hasn't been told. I am a mining engineer and I read geology, I read pushback, and there is sulfide.
And you now to be saying that because it was always known that there will be a concentrator plant in the concession, this is why the 1998 stabilization agreement covered the concentrator plant, correct?
Lo que estoy diciendo es que
What I'm saying is that if one looks at this, it was there. And when I mention the figures, I say this is the mine equipment because they are doing stripping. What are they doing the stripping for? For the primary sulfate. They're taking care of that. That stripping to send it to a plant. These were oxides, and they were processed there. And whoever is there carries out the stripping and piles up the oxides in a corner. So it is a different way to process. I want you to understand this is a hole like this, and you start to remove from top whatever you have on top, that is the oxides that have copper, a very high copper content. You move it on to the leaching plant, you take out the copper, and you continue to go down to get to the primary sulfates. And those sulfates need to be processed in a concentrator.
Long answer. Anything that related to my question, but Madam President, I'm coming back now to your point. I'm not going to complete today, so we can stop now or at any point convenient to the tribunal. I'm happy to stop now and continue tomorrow.
We note that respondent needs more time for cross-examination or requires more time, so that we cannot complete today. Our general understanding was that we try to avoid in our hearing witnesses now also the next day. So we hope that within the next days we will catch up a little bit again with our hearing schedule and stick to the agenda as originally agreed between the parties. I think now it is what it is. Now we will also have some questions to Ms. Chapuis, and so maybe you can tell us tomorrow morning what your plan is in terms of timing.
Well, Madam President, so I was hoping to complete tonight, but it turned out to be impossible. I'm sure you and your colleagues have heard that many times. That counsel blames the witness, but we received some long answers that I don't believe were answers to my questions, so I had to repeat questions over and over again. If Ms. Chapuis, and I'm asking her to cooperate with me and provide short answers, I'm hoping to complete within 1 hour tomorrow, but of course there will be redirect and questions from the tribunal. But I'm hoping that I can complete within 1 hour tomorrow on the assumption that Ms. Chapuis cooperates with me. I'm trying to ask specific questions, and I will ask her, I will plead with her to provide short answers.
This is understood. Any comments from claimant side?
My only comments are that experience from the previous arbitration shows that respondents' witnesses are also very talkative. So we will have to deal with that. But each side has an equal amount of time, and each side can spend it the way that they want. So I can't promise that just because Mr. Alexandrov chooses to cross-examine Mr. Chapuis for longer, that just to catch up with the daily schedule, we will be shorter with our witnesses. But in the end, we're all going to catch up because we all have the same amount of time, and it's respondents' choice to spend more time on fact witnesses. They're going to have less on the experts. That's a strategy choice that they have to make.
And we certainly respect the strategy choice. We just wanted to make the point that we hope to progress.
Yes, Madam President, and we maybe we misunderstood it. We understood the schedule to be tentative in the sense of we may decide to take more time
Yes,
with one
it
witness
was
and less time
tentative,
with
always
another.
meant.
But yes, it's the chess clock. We know we have a limited amount of time, so we will have to catch up at some point in time, and we will, of course, not only try to do that, but we will have to do that. Thank you.
Then we wish all a peaceful evening, good rest, and see us tomorrow.